We're going to be talking about the ongoing labor and employment challenges in California, presented by Bruno Katz. Bruno is a partner in the Wilson Elser law firm. I call him Mr. San Diego because he's California through and through, but he understands California labor and employment law like no one else. He's 2023 member of the Best Lawyers in America, and he's a board member of the California Restaurant Association San Diego chapter. Ladies and gentlemen, please welcome Bruno Katz.
Thanks so much, Stephen, for your kind introduction. We have a lot to cover here in the wild world of California. Some of this stuff is enhancements that we don't see in other states that Andrea and Jordan talked about. And I'm just going to start off with some enhancements that exist. The California Family Rights Act lays right over FMLA, but unlike FMLA, it's applicable only to 5 or more employees. It still gets your 12 weeks unpaid leave. And just this year, they expanded the definition. You know, the old meaning was basically you could take it for a family member. Now, as of January, this includes anybody that is related by blood or whose association in your estimation as an employee is the equivalent of a family member. The one issue that they did deal with the legislature here in California is that limits to one designated person per 12-month period. So if someone is outside the child, parent, parent-in-law, grandparent, grandchild, sibling, spouse, or registered domestic partner, you can designate someone else, but you need to say who that person is for that designation. So the Family California CFRA, most employers nationally still call it FMLA, but it is not. It is for smaller employers. It's unlike the FMLA, which are larger employers. You need to have more employees. The CFRA is for a much smaller subset, so it applies to a much greater list. And when you're dealing with small operators and small hospitality companies, it applies to them too. If we could go to the next slide, Marilyn. Along those same lines, California was one of the first states that required paid sick leave. It's 24 hours, and we'll talk a little later as to whether that's going to exist. I will tell you that many, many jurisdictions require paid sick leave above the California norm. And for those of you who are familiar with labor and employment law, you can always make it more restrictive. If a federal has a rule, the states can make it more restrictive. If the state has a rule, the municipality can make it more restrictive. So there are instances where, for example, in San Francisco, I think it's up to 67 hours of paid sick leave. But much like the CFRA, the California Family Rights Act, paid sick leave has now a designated person above and beyond your family members. And you can use it for medical diagnosis, treatment, or preventive care for that designated person also. Once again, the designated person is limited to one designated person outside the normal family unit for a 12-month period. So that is that restriction, because a lot of people would like to use the paid sick leave for other reasons. And paid sick leave, for those of you that deal with it, can pretty much be for anything. If they ask for the sick leave, it really isn't your place to inquire what it was for. They can just say, I'm taking a sick day, and you pretty much need to give it in California. For those of you who are unfamiliar with California law, you need to track that on the pay stub too, as to how much paid sick leave they have, how much is remaining. And we could talk much more expansively about whether you do an accrual method or whether you front load it. But paid sick leave is here to stay in California, and we'll talk at the end. They're going to probably amend it again. So something coming up the horizon. If we could go to the next slide, that'd be great. California, unlike other states, now has mandatory bereavement leave. It's unpaid, and it can be used. You can use your vacation, your PTO, or personal leave for it, but it's required now. It is required in your handbooks, if you have them, that you need to make clear to all employers who have 5 or more employees that they need to provide up to 5 days of unpaid leave for the death of a family member, and that includes, the child, the spouse, the sibling, grandparent, grandchild, domestic partner, or parent-in-law of the employee. It doesn't have to be taken consecutively, but it must be completed within 3 months of the death. And the employer can ask for documentation. A lot of these other things like paid sick leave, you don't typically ask for documentation, but you can ask for a published obituary, a verification from a funeral home, a death certificate, something to verify that, in fact, you are taking a bereavement leave. It is justified, and so you do need to do that. So if you're in California, you need to understand that bereavement leave is required. It is unpaid, and it also can be used in conjunction with other leave. If we could go to the next slide, that'd be great. California is unlike, when the Supreme Court handed down its recent decision overturning Roe v. Wade, California was not affected because it's always protected the rights to choose. But the legislature decided to make a new grounds for discrimination. It's a new protected category in California, and that's reproductive health decisions. And that includes, you can't discriminate if a person wants to use a particular drug, a particular reproductive device or product or medical service related to reproductive health. You can't discriminate. You don't often get into these issues, but in California, like I said, is a state that wasn't affected by the overturning. But the legislature has decided to pass this as a new grounds of discrimination. I'll also note for you, if you don't already know, Andrea talked, about protections. There isn't specific federal protections for gender identity or gender expression. We've had those protections in California now probably close to 10 years. That is a protected category. We've also had single-sex restrooms in California for probably 8 years. For those of you who don't know, that if you only have one area to go to the restroom, that has to be a single-sex restroom. It is mandated by law. So if there's only one toilet, it must be single sex. So we've been dealing with those issues for a long time in California, and it actually is a protected category here. Let's jump to the next slide if we can. Emergency conditions. As many of you know, in the hospitality industry, you don't want people walking around with their cell phones, ringing cell phones, interrupting things, but California has made it clear and prohibits an employer from taking any adverse employment action, which could mean termination, it could be suspension, it could be demotion, if the employee has a reasonable belief that a workplace is unsafe due to an emergency condition. Emergency condition is defined as including any nature or criminal act, a disaster, extreme peril to the safety of the person, or order to evacuate. If someone, it could be considered an emergency if someone thinks some kind of illness or epidemic is going on. And it's unlawful to prevent that employee from using their mobile device to seek assistance, assess the safety, or communicate to verify safety. So a lot of employers are having to deal with this. This is effective January 1, 2023 also, that if an employee has a reasonable belief, not an unreasonable belief, but a reasonable belief the workplace is unsafe, you have to let them be able to use their mobile device to seek assistance. And if you don't, and if you threaten adverse employment action, you could be subject to an additional grounds of liability. Usually, if it's an emergency condition, you'll know: earthquake, fire, tornadoes. We do get those occasionally in California, not often. But like a shutoff of water, a health and safety issue, some kind of outbreak. Usually the employer realizes that and they'll shut it down on their own, but this provides an added protection for the employee, as we have in California for a lot of very employee-friendly state, to take care of the emergency condition. If we could go to the next slide. California now has pay transparency laws. Some of you have to do pay transparency on a federal level, but California requires it if you have 15 or more employees. So you have to post, when you're doing a job posting, the pay scale. And that includes if you use a third-party vendor. You have to post the pay scale for that particular job. And then effective every year, a private employer, and that's for all employers of 15 or more. But if you're an employer of 100 or more, you've got to submit pay data now to the newly named California Civil Rights Department. Some of you, if you do business in California, may remember it as the Department of Fair Employment and Housing. They've renamed it the Civil Rights Department. They're in transition. And you have to report the annual median and the mean of the hourly rates based on race, ethnicity, sex, category hired through the labor contractors, new obligation to produce the hours on pay, hours worked, race, ethnicity, and gender in a separate report. So you have the small employers have to post it, even if you do Indeed or Monster or whatever third-party vendor of the pay scales for transparency. And if you're a large employer, you have to provide additional information, much like if you're a federal contractor dealing with affirmative action issues. So that's new to California also. Let's go to the next slide if we can. California also has some of the strictest Privacy Rights Act. It requires a privacy notice be given to employees on job applicants at the time of collection of personal information. Enforcement's going to start just in a few weeks on July 1st. They've had this for consumers for a long time about that information. It now goes to employees. You got protections generally on personal information. If you mishandle issues about children, it could result in $75,000, $7,500 per penalty. The scheme has existed more for consumers and people who collect consumer data. And now it deals with employees. Generally, it's a long and convoluted thing. And since we're covering a lot of different, kind of an overview of what we live in California, we're going to move on to the next slide. California now also has CalSavers. That is, if you don't have a company-sponsored qualified retirement savings plans, you need to notify them. And CalSavers is the government state-run retirement savings program available to California workers. So if you're an employer of 5 or more, and you only may, 4 of them may not qualify for CalSavers, but if you have one that does, you have to advertise it to your employees as an option that they can utilize that for a workplace retirement plan if you don't offer it. So that CalSavers is the state-run one. The program is up and going the next 36 months. Eligible employers with 5 or more employees that don't offer it must at least have a payroll deposit retirement saving arrangement to allow employee participation in CalSavers. So this is a requirement for employers. You must at least offer it, much like under the ACA, Obamacare, you had to offer it. They don't have to take it, but you have to at least offer it. So that's another thing that employers are facing here in California. Let's move on. We talked about cannabis. Jordan talked about cannabis. This law is effective January 1, 2024. It will now be unlawful. And we have recreational cannabis that's been allowed in California now for a couple of years. We've had, which is legal, but now it is unlawful to discriminate based on a person's use of cannabis off the job and away from the workplace. Use of the employer drug screening test. You can't discriminate if it is that found non-proactive cannabis metabolites. The cannabis metabolite is THC, but if you find other cannabis metabolites in your hair, blood, urine, or other bodily fluid, you can't use that as a screening not to allow them if it's non-psychoactive, because there are other metabolites out there. There are cannabis products that don't have that. You can still use a valid drug test for screening for current impairment. Of course, there are exemptions. If you're in a safety-sensitive position, those in the transportation industry, those doing heavy machinery, those requiring a federal background or investigation clearance, that will be exempted on this cannabis discrimination. Of course, it doesn't ever permit or the possession, use, or impairment by cannabis while on the job, or the employee right to a drug-free workplace while they're working, but is now grounds for discrimination, which will happen as of January 1, 2024. I think the next slide, I want to talk about a unique law that's been in there, California, for quite some time that many of you might not know about. It is called the California Private Attorney General's Act. I just want to give you an overview. This is basically a way for you deal with class actions, and there are certain specific requirements for class actions. This is a way of getting a class without meeting all the requirements. It basically allows private attorneys to act as the California Attorney General to enforce labor and labor terms, wage and hour, discrimination, retaliation, and it has a penalty structure. And so if the California Labor Commissioner decides not to investigate once given notice, they can file these PAGA actions, and they've been able to do this for quite some time. And when there is a settlement, 25 of any penalties goes to the employees, the 75% goes to the state. But it really drives the attorney's fees. Let's go to the next slide. It only covers the 1 year prior to the PAGA notice, so you have to give a notice going back, and then obviously going forward as you deal with this. As you can see, their penalties, the default is 100 per violation, and then 200 for subsequent violations. Meal and rest periods has slightly lower. Wage statement violations have higher ones, but the good news is the courts have said that just because you do it once and maybe you do it again, if you didn't know that the conduct was violative of the labor code, you don't get penalized the higher penalty. But that said, if you look at the penalty each and every one of these times, the penalties are enormous. And we go to the next slide, Marilyn. We have the ability to stack it because under the labor code, there are certain statutory penalties. Under this is civil penalties. So you can get fined not just statutorily, you can get fined civilly. And there's no class action requirements. You can proceed even when the plaintiff has found they don't have any actual damages because they're doing it on behalf of an aggrieved party. So even if they've suffered no injury and you've proved they've suffered no injury, the case still goes forward. There are even instances where the plaintiff has been found as a matter of law to have suffered nothing. There's an actual adjudication. They can still proceed. So the case continues going on forward, and you have to have the requirement, the judge, to settle any of these. You can't just dismiss them because you're going to dismiss the individual claim, but the aggrieved party claim continues. There is a proposition in California to eliminate PAGA under its current structure. And what it basically is saying, take it out of the private attorneys. We're going to give more money to the labor commissioner to prosecute this and have them do their job. Because what the labor commissioner does, even though they've been funded a lot, is they just don't decide to do the enforcement. So this is going to make the labor commissioner enforce it, take out the attorney's fees issue, take out the additional penalties issue. There's great discretion in reducing these, but every judge I come across hates PAGA, but it is the law, and it's what we're living with here in California right now. So it definitely increases liability in a class without meeting the class connotations. Let's move on to the next slide. Employment arbitration in California, there are certain conditions. You got to have a neutral arbiter. You have to have a written award. The employer has to pay any fees and costs above and beyond a normal court filing case. And you have to have the same relief from the arbitrator as you get in court. There was a big issue, I don't know if people tracked it, but when Viking River was decided, it basically dealt with PAGA by basically saying, before California Supreme Court said you couldn't divide PAGA claims and individual claims. But so if an individual has agreed to arbitrate their individual claims, you couldn't do that if you had PAGA. And so you had to keep it in court. Viking River basically said they are divisible, but if they're divisible, the PAGA claim can't exist because you didn't consent to it in the arbitration. The California Supreme Court has taken that issue, and they're probably going to clarify it, and they're probably going to try to rewrite PAGA so it's clearer that so the U.S. Supreme Court doesn't do it. What does that do for employers going forward? It's going to be hard to say, but the state courts are basically enforcing arbitration on individual PAGA claims, putting the class claims, the PAGA aggrieved party claims to the side and staying them until the California Supreme Court decides, and then who knows if it goes back up to the Supreme Court. The one good news for employers on arbitration agreements is they passed legislation a couple of years ago saying you can't require employees to sign an arbitration agreement as a condition of employment. the Ninth Circuit recently ruled saying you can. So employers are now can require as a condition of employment that you sign a binding arbitration agreement. And so that's, employment arbitration is a moving target in California. And both of those issues, the class and the PAGA issues, may go out. Unless you have an express, you also can't force class claims into an arbitration unless it specifically says it's arbitrable, because you have to consent. There was a difference of opinion on that, but it's been made very clear by the U.S. Supreme Court and now the California courts that if you must have consent to force anything above and beyond your normal arbitration clause. All right, let's go to the next slide. Some laws that were passed but now are stayed. For those of you in the fast food industry, California passed what is called the FAST Act. It was supposed to start this year. Basically, it created a fast food council of 10. There were supposed to be fast food representatives on the council, but the vast majority, 6 of them, comes from the employee side and basically the union side. It applied to any fast food restaurants with 100 or more locations. Some of you are probably saying, well, a lot of fast food restaurants are franchisees. Well, all it mattered was if you're flying the flag. So if you're a Wyndham or you're a McDonald's a McDonald's or an In-N-Out or other that have 100 or more locations nationwide, even if they're not owned by the same person, you were subject to this. There was a presumption minimum wage of $22 an hour that was supposed to start. And this was an independent council, a council that didn't report to anyone. It had to give reports to the legislature once every 3 years, but basically they were free to act as the labor commissioner for fast food outside of the restrictions of the California Labor Commissioner's Office. Obviously, the fast food industry nationwide was very concerned about this, as well as other hospitality franchises, because this was step one. It was very, very clear by the union. This was step one that they wanted to do. This has been stayed. There is a pending referendum that will go to the voters on 2024 as to whether this will continue to exist or not. So there is not a fast food council of 10 with the lack of accountability. The voters will decide in California whether this makes sense. Obviously, operators are very concerned, not just from a fast food industry, but also from the restaurant industry, because if minimum wage is going up to 22 in fast food, that means that to get workers in other hospitality industries, you're going to have to pay them at least $22 an hour, which is problematic for a lot of people. So they're concerned that obviously this will be passed on to consumers, increase food costs, and everything like that. So this has stayed right now, but this is a new innovation that California's come up with. I know other states are looking at it, but it's stayed right now because we're going to go to the voters on this issue in 2024. Let's go to the next slide. To give you a sense of what's going to happen going forward, these are bills that are currently pending, and these are the ones that I pulled out that I thought was very likely to deal with hospitality. The first one is California wants to expand the joint employer liability definition. Under the current proposal, and it's gone through what's the California's House, it now goes to the Senate. And understand California's a supermajority, so this is likely to pass, where they're going to hold a franchisor liable for the franchisee, even if all the franchisor does is provide general requirements you have to do. The franchisor does not regulate the employees of the franchisee or anything like that. They are talking about doing joint employer liability for the franchisor. So obviously those in the hospitality industries with the big brands are watching this closely, that if this does pass, and who knows about the constitutionality of it, they're going to try to hold both the small franchisee, the one that's, maybe the small hotel that's flying someone's larger flag, or the small restaurant flying a larger flag, liable, the big entity. It's a way of getting to the deeper pocket. So that's one thing that's pending. Two, expanded protective leave to anyone we talked about a designated person, but they want to expand it even more, so that an employee can deem that person equivalent to having a family relationship. And if you deny that leave, they want to put a presumption that you're retaliating against the employee, saying, I want to take a protective leave because this person I believe is like family to me. And if you say no, that's going to be deemed to presume to be retaliation. So you have to overcome that presumption. Both of these pieces of legislation, is my understanding in talking, are likely to pass. Another thing that's proposed, and I don't know if this one's going to pass, is where you've got the labor commissioner's office and the state doing enforcement of labor codes. They're now going to ask that public prosecutors, so any city, municipality, or public prosecutor can do the same thing. We're already seeing that popped up where there's redundancy going on in certain municipalities in Sacramento. San Diego's trying it where they're creating their own labor commissioner above and beyond in redundancy to the California Labor Commissioner's Office. They're also talking about applying workplace violence prevention. So if you see something, you have to do special reporting, the same kind of special reporting to all industries that you would have in the healthcare, where they are specifically trained to look at these kind of issues, sexual assault and abuse. They're trying to do that on all industries. They're also trying to do a restriction about attending any meetings that could be political. Labor unions, of course, are exempt under this, but political is broadly driven, even if it's just educating people on new laws and policies, that could be deemed overly political, and that could be a bar, and that could be deemed discrimination. Also, this last one is going to pass. They're going to increase the paid sick leave in California and statewide, a minimum to 56 hours per year, which is 7 days. So 7 days of paid sick leave is required. You can roll it over up to double, but you need to put it in writing. So you're going to see increased paid sick leave. There are many municipalities and that are talking about increasing it even more than 56 hours. There's also municipalities that are talking about imposing even more minimum wages above and beyond the California minimum wage right now, which is $15 an hour, but most municipalities are more than that. It's tied to Consumer Price Index. State of California has put a tie on stopping it percentage-wise to no more than 10%, the CPI. If the CPI goes above 10%, that's the most we can increase it. But some municipalities are not tying it to Consumer Price Index. So, for example, San Diego jumped 13% in the minimum wage. So this is what we're dealing with in California. It obviously affects hospitality. I think I'm out of my time. I think we need to end at 9:30, and hopefully, I know that was a lot of stuff to digest, but wanted to let you know what's going on here in California and maybe could be going on in other states, because some states like to follow what California does. So thanks.
Yeah, Bruno, thank you. I've often said that we get wowed by what's going on in California, but we have to remember a lot of things start in California and head east. So they really do. And so that great information that you provided us. Thank you very much. Bruno, can you still hear me?
I can hear you. Yes, Stephen.
Yeah,
so.
I just have a quick question. You know, we read from time to time that all of these labor challenges are kind of stunting the growth of business in California. But my experience, and I travel to California a lot, as you know, is that California is humming right along. But in your experience, are you seeing a slowdown because of these regulations?
I'm seeing more closures because of this regulation. There are some people who are saying, I can't make it anymore, I'm going to shut down. Obviously, COVID had a huge effect on that. People are still coming out of it. But I am seeing the small businesses are being negatively affected. A lot of small businesses, a lot of small operators are saying, I can't do this anymore. I'm gone. I need to go. I'm going to shut down. I'm going to do something else. That I am seeing. It is a challenge if you're a smaller operator. And California is, for the first time in a long time, and nobody talks about this, it was a surplus even through COVID. It is now a significant deficit. that is going on. And, you know, all of this is not going to help things. The legislature is basically beholden. It's a supermajority, and the people that are driving the legislative agendas used to be legislatures, and now they're embedded in the unions, and the people who used to propose these things, the unions are proposing them to their people that they're controlling. So this is a test, and Stephen knows this. I said a long time about living wage issues. California was a test. Stephen knows this. Back in Northern California, when we had a small hotel company fighting some issues involved with the National Labor Relations Act, I said this is going to LAX. It did, and it continues. So California is definitely the test case, and there are no checks and balances here. There's a supermajority, so it's a difficult time, and there's more and more requirements. I don't know where that's going to leave us, but it definitely, we have challenges from an employment standpoint. It's hard to keep all the new rules and regulations because every year it changes. So but it's affecting the small operators. That's for sure.
For sure. Well, Bruno, can't thank you enough. That was a lot of work putting that information together, and you did it brilliantly, as usual, I might add. Thank you. Ladies and gentlemen, let's say thank you to Bruno Katz, and that's going to wind up our day. I'd like to say a quick thank you to Andrea Ryan with Fisher Phillips, Jordan Schwartz with Con Maciel, and of course, Bruno Katz with Wilson Elser. Thank you all. So ladies and gentlemen, that wraps us up today. We greatly appreciate your time and attention. Be on the lookout for notification about our next webinar in this series, and we'll look forward to seeing hopefully all of you in Washington, D.C. Thanks again, everybody. Have a wonderful day.